Slam dunk, are you ready to meet me? I'm lit and I'm riding the fast lane. Don't let me down, I'm on fire. Does anyone else feel like a liar? It's all in your head and right. You just never use it.
Session 2 of the Walker-Moot Supreme Court in the Borden Ladner Gervais courtroom is now in session. So first and foremost, we would like to acknowledge that we are speaking to you today from the traditional unceded territory of the Algonquin Anishinaabe people. We speak today while paying respect to the traditional knowledge keepers and the Algonquin people and all Indigenous peoples in the region of Ottawa who call the national capital their home. If you are not located in Ottawa and do not know about the traditional territory on which you are located, we encourage you to navigate to websites like nativeland.ca to find out. And we also encourage you to learn more about decolonization by consulting the TRC calls to action as a starting point. So it was great honor and privilege that I present the justices today. So first, Dr. Vivek Rao. Dr. Vivek Rao is the Chief of Cardiovascular Surgery at the Toronto General Hospital, where he is the Surgical Director of the Mechanical Circulatory Support Program. It is also with great honor and privilege that I present Justice Valerie Wise from Wise Health Law, Justice Duncan Embury from Neinstein Personal Injury Lawyers, Justice Elena Mamey from Borden, Ladner, Gervais, and Justice Catherine T. Di Tomaso from Steiber Burlak LLP.
If I may, Isabel, I would just like to say that for today's session, I'm also going to be a substitute judge. My name is Lucas Lindsay. I'm a student at law at Pappas Law, and my most relevant credentials at last year I watched 9 moots. So take for that as you will. And just so you know, I will be a judge. I don't have the screen, but I'm here as well. All right.
Okay, and the facts before us today are that on October 19, 2021, after battling COVID-19 for 18 days, Kyla Stark died in the ICU ward of Fallview Health, 13 hours after her transfer from West Valley Memorial Hospital. Mrs. Stark's medical records reveal she was in perfect health and she had no previous existing medical conditions, nor any prior family medical history that would indicate otherwise. She was double vaccinated as of August 1st, 2021. On October 1st, 2021, Ms. Stark tested positive for COVID-19 and contacted her longtime physician, Dr. Sophia Strange, and obtained a prescription for ivermectin. Though all pharmacies in her area were out of stock, Ms. Stark's condition was stable. On October 5th, Ms. Stark was notified that her local pharmacy had just stocked ivermectin and her prescription could be filled. But that same day, Ms. Stark had developed severe shortness of breath and mild hypoxia and was admitted to the defendant's hospital, where she was placed under the care of Dr. Myrtle Papadopoulos, a third-year medical resident. Ms. Stark immediately requested Dr. Papadopoulos administer the ivermectin her family physician had prescribed, a course of treatment which she chose to reject. On October 6th, Ms. Stark was moved into the ICU and placed on a nasal cannula during the day and a BiPAP at night. Ms. Stark was treated with the hospital's COVID-19 protocol, which consisted of dexamethasone, 6 milligrams IV, and pure oxygen. On October 7th, ivermectin was administered after Ms. Stark's family pleaded with Dr. Papadopoulos. Within 11 hours, Ms. Stark's condition had improved greatly. However, the supervising physician on staff, Dr. Lutsier, chose to withhold any further administration after being informed of Dr. Papadopoulos' use of ivermectin. On the evening of October 8th, Ms. Stark's condition worsened and she was sedated, intubated, and put on a ventilator. Almost immediately thereafter, Dr. Lutsier was contacted by Dr. Strange, who strongly requested ivermectin continue to be administered, in addition to MATH plus protocol. In response, Dr. Lutsier asked Dr. Strange to forward him the relevant literature for which she was relying on so that he could make a rational and educated decision, which was provided immediately after. Dr. Lutsier determined his time would be better spending to his patients than reading what he referred to as propaganda. On October 10th, ICU nurse Dolores Patel was convinced by Ms. Stark's family to speak with Dr. Strange over the phone. Dr. Strange pleaded with Nurse Patel to administer the frontline COVID-19 Critical Care Alliance MAT Plus protocol. Nurse Patel spoke with the attending physician, Dr. Andy Park, and convinced him to undertake Dr. Strange's request. Within 15 hours, Ms. Stark's ventilator was turned down, and Dr. Park and hospital personnel began the process of trying to bring her out of the medically induced coma. On October 11th, Ms. Stark's condition had improved, at this point having only to rely on a nasal cannula. On the morning of October 13th, Ms. Stark's family was informed by Nurse Patel that the hospital had misplaced the ivermectin, but there was no need for concern as Ms. Stark was making great progress. However, Dr. Lutsier once again assumed care of Ms. Stark, and upon learning of the patient's treatment course, chastised Nurse Patel and the medical staff for administering the MATH plus protocol. Dr. Lutsier then administered remdesivir to Ms. Stark. Nurse Patel phoned Ms. Stark's family and informed them that Dr. Lutsier had assumed care and denied any further administration of the MATH plus protocol. The family was unable to reach Dr. Park, who was volunteering in Sudbury as part of an initiative to help provide critical care to patients battling COVID-19 in rural communities. At 1:27 a.m., Ms. Stark's oxygen level began to drop and she became unstable. Within 3 hours, Ms. Stark was again placed on a ventilator. The family arrived at the hospital, but was denied access due to the hospital's COVID-19 protocols in place. Mr. Stark phoned Dr. Strange and pleaded with her to get involved. Dr. Strange placed several phone calls and emails to Dr. Lutsier, but after 4 unsuccessful phone call attempts, decided to drive down to the defendant's hospital in an attempt to manage the situation in person. Upon her arrival, Dr. Strange was too denied access to Ms. Stark and was unable to speak with Dr. Lutsier. Within 6 hours, Ms. Stark's chances of survival had dropped to 20%, and Dr. Lutsier informed Mr. Stark that he had exhausted both his course of treatment and COVID-19 protocol in treating Ms. Stark. Mr. Stark pleaded with Dr. Lutsier to administer the MATH plus protocol and offered to sign a release, releasing Dr. Lutsier and the hospital and any of its agents and parties acting on its behalf from any and all liability arising from administering the MATH plus protocol to his wife. However, Dr. Lutsier refused to administer MATH plus protocol, and a verbal confrontation ensued outside between Mr. Stark and medical staff, and security removed him from the building. On October 19th, Dr. Lutsier agreed of the transfer of Ms. Stark to Fallview Health, where Dr. Strange was on staff and would therefore be able to assume care for her. However, less than 1 hour after arriving at Fallview Health, Ms. Stark died. In this matter, the questions at issue are the following. Issue A, standard of care. What is the requisite standard of care for medical negligence in Canada as correctly applied to this case? Did Dr. Lutsier breach that standard of care in A, failing to investigate the literature he was provided with, and B, denying Ms. Stark's treatment with MAT plus or ivermectin alone? Issue B, causation. Did Dr. Lutsier conduct cause or contribute to the harm or injury Ms. Stark sustained? Issue C, vicarious liability. Is the hospital vicariously liable for Dr. Lutsier's actions? And justices of the panel, I present to you speaking on behalf of the plaintiff, Mr. Stark, in today's matter before the court, Kayla Sager and Kate Hunter. And speaking on behalf of the defendant, Dr. Lutsier and the West Valley Memorial Hospital, Nicole Davidson and Manit Kahlon. We are here today to determine the outcome on trial before the court on the matter between Mr. Stark, Dr. Lutzier, and the West Valley Memorial Hospital. Both the plaintiff and the defendant's counsel will have 30 minutes each in total, 15 minutes each counsel member, to present their arguments to this court, including answering questions from the bench. The plaintiff will present their arguments first, followed by the defendants, and then a 3-minute rebuttal may follow by the plaintiff if they so choose. I will signal to the court by the chat when there is a 5-minute left per speaker. The court now invites counsel for the plaintiff to begin.
Good morning, Justices. My name is Kate Hunter, and I, along with my co-counsel, Ms. Kayla Sager, appear on behalf of the plaintiff, Mr. Sam Stark, the husband of Ms. Stark. Justices, my co-counsel and I seek to advance 3 submissions today. Firstly, that Dr. Lutzier breached the standard of care in 2 ways. Firstly, when he failed to administer the Math Plus protocol or ivermectin alone, thereby depriving Ms. Stark of potentially life-saving treatment. And secondly, that Dr. Lutzier breached the standard of care when he failed to review the relevant literature sent to him on October 8th by Dr. Strange. Our second submission is that the damages sustained by Ms. Stark were caused by Dr. Lutzier's negligence. And our third submission, that West Valley Memorial Hospital is vicariously liable for Dr. Lutzier's negligence. I will speak for 15 minutes on the first submission today, and my co-counsel will speak to the second and third submission for about 15 minutes today. We submit that Ms. Stark suffered damages as a result of Dr. Lutzier's negligence, and as such, the plaintiff is entitled to roughly $12 million. I will now begin with my first submission. In order to succeed in an action of negligence, the plaintiff must prove 4 prongs. Firstly, that the defendant owed them a duty of care. Secondly, that the defendant's behavior breached the standard of care. Thirdly, that the plaintiff sustained damages. And fourthly, the damage was caused by the defendant's breach. We have 2 submissions today in which Dr. Lutzier breached the standard of care. Firstly is when he failed to administer and withheld the Math Plus protocol or ivermectin alone. The standard of care for physicians is to exercise a reasonable degree of care, skill, and knowledge that would be reasonably expected of a normal, prudent, and diligent doctor of the same experience or standing. This is the standard that Dr. Lutzier breached and that we hold him accountable to today. To determine the standard of care in treating COVID-19 and to contextualize and evaluate Dr. Lutzier's behavior, we must evaluate what physicians of similar experience and standing would do in treating COVID-19. We are fortunate to have 2 physicians that share very similar credentials to Dr. Lutzier and who operate in very similar capacities, Dr. Strange and Dr. Titchener, whose credentials can be found at paragraphs 4 and 5 of the plaintiff's factum, are both active in critical care medicine, internal medicine, and pulmonary disease. Dr. Titchener has also run multiple ICUs in COVID-19 hotspots around the globe during various surges. Dr. Titchener and Dr. Strange both assert that Math Plus is the standard of care in treating COVID-19. Math Plus is comprised of FDA-approved components and has shown to reduce the escalation of COVID-19 by targeting and mitigating the processes that impact the severity of COVID-19. Ivermectin also has extensive support as a safe and low-cost treatment that counters the body's inflammatory response to the COVID-19 virus. While we do concede that supportive care is used in some hospitals in treating COVID-19, there is a reason that West Valley Memorial Hospital's guidelines are not Math Plus or ivermectin, despite their effects. This is because Dr. Lutzier made the hospital's guidelines. Dr. Lutzier testified to not having read the studies on Math Plus or ivermectin, or at most, having skimmed one singular study. If Dr. Lutzier was not familiar with the relevant literature, then of course this wouldn't translate into the hospital's COVID-19 treatment protocol. We should not confuse the guideline that Dr. Lutzier created, which advocates for supportive care, to be the standard of care when treating COVID-19. The guidelines at West Valley Memorial Hospital should be assessed in light of external indicators of reasonable conduct. For example, a physician would have to modify a guideline treatment plan if a patient had specific allergies or was not responding to a proposed treatment plan. Supportive care is just that, supportive. It is not active treatment. As such, physicians should use their best clinical and moral reasoning and judgment to make decisions carefully based on their patients' needs and responses to proposed treatment plans. Physicians have a duty to take an active role in the treatment of their patients. This does not mean administering treatment and then paying no mind as to how the patient responds or looking for no alternatives if no improvement is seen. This is not the standard of care, nor does it meet the fiduciary duty established in a patient-physician relationship. Even if we determine that the standard was supportive care, this does by no means remove the culpability of Dr. Lutsier from refusing to take an active role in the treatment of his patient. Dr. Lutsier never once questioned the improvement in Ms. Stark's condition after the administration of ivermectin and MAF+, but rather chose to continue blindly ahead with a course of treatment that was showing no effectiveness. Dr. Lutsier watched Ms. Stark deteriorate, not improve under the proposed treatment plan, and did nothing. Having determined that he had exhausted all his preferred methods of treatment, Dr. Lutsier waited 6 days to agree to transfer Ms. Stark to a physician who was ready to treat and take an active role in her care. During this unacceptable delay, Ms. Stark wasted away, and by the time Dr. Lutsier agreed to transfer her, it was too late. Ms. Stark died within 1 hour of her arrival at Fallsview Health. This does not sound like the behavior of a diligent and prudent physician. This was more than laziness or a simple misjudgment. This was negligence. Our second submission as to how Dr. Lutsier breached the standard of care was when he failed to investigate the relevant literature sent to him by Dr. Strange. On October 8th, Dr. Strange, one of the top critical care specialists in the country, and Ms. Stark's general practitioner, forwarded Dr. Lutsier the relevant literature on ivermectin and the MAF+ protocol. At this point, Ms. Stark's condition was worsening. She was sedated, intubated, and on a ventilator. Her condition was not improving under the current treatment plan. The literature Dr. Strange emailed to Dr. Lutsier included multiple peer-reviewed and evidence-based studies on the efficacy of using the MAF+ protocol and a real-time meta-analysis of 77 studies using ivermectin to treat COVID-19. I know your honors do not have the moot problem in front of you, but on page 87, Dr. Lutsier testified, and I quote, "MAF+ is an experimental and unproven treatment preferred by a group of brainwashed anti-vaxxers." This is the view that Dr. Lutsier held without reviewing any of the studies sent to him by Dr. Strange. When presented with the alternative of reviewing literature sent to him by one of the top critical care specialists in the country, which advocates for an alternative treatment, or watching your patient die, Dr. Lutsier chose to not review the relevant literature. Dr. Moriarty, an expert witness for the defendant, confirmed in his testimony that if a physician were to ignore these results, label them on their face without review as anti-vax propaganda, that this would constitute a breach of the standard of care. And this is because medicine is not a stagnant practice. With improvements in technology and global pandemics that take the world by surprise, the standard we hold our physicians to is not one of perfection, but one of active and diligent care and reasonable prudency. The Canadian Medical Association Code of Ethics, and this quote can be found at paragraph 28 of the plaintiff's factum. The Code of Ethics quotes, "A prudent physician uses clinical and moral reasoning and judgment, considers all relevant knowledge and circumstances, and makes decisions carefully, in good conscience, with due regard for the principles of exemplary medical care." The College of Physicians and Surgeons of Ontario echoes this in their practice guide about the duty to maintain and be responsible for physicians maintaining their medical knowledge and clinical skills relevant to developments in the medical community. This can be viewed as what is encompassed when we describe the standard of care of a prudent and diligent physician. Dr. Lutsier did not need to seek out this information himself. The relevant literature was sent directly to him. It could not have been more convenient for him to review it and make an informed decision. Dr. Lutsier's failure to—
Ms. Hunter, may I ask a question?
Absolutely.
There's a body of law that says that where there's competing schools of thought, it's reasonable for a physician to follow either or one of those competing schools of thought. And can I ask that you address that in terms of whether supportive care in your submission is a reasonable alternative and therefore a competing school of thought that was open to Dr. Lutzi?
Supportive care is used by some hospitals in treating COVID-19. So we do submit that it is an option. However, in the case of Ms. Stark, who was a 28-year-old woman, she was healthy, double vaccinated. The plaintiff submits that when Dr. Lutzier noticed that Ms. Stark was not improving under the current treatment plan, that he had a duty under his fiduciary duty to seek out an alternative method. And when presented with the relevant literature sent to him by one of the top critical care specialists in the country, that he owed Ms. Stark to act in her best interest, which was to review an alternative method and to pursue that as treatment. The thing with COVID-19 is it's so quickly changing. We have the NIH, who had previously, and Dr. Lutzier relied on this, labeled a negative rating for using ivermectin in the treatment of COVID-19, has switched in January 2021 to a neutral stance. The research is so quickly evolving that physicians have a duty to be up to date and to act in their patients' best interest and potentially modify their treatment plans.
Thank you so much, Ms. Hunter. I have a question. Doesn't the novelty of COVID-19 cut both ways? In other words, the standard of the doctor is reasonableness, not perfection, as you've pointed out. When dealing with a novel virus, is it not suitable for the doctor to choose a reasonable course of action, not each and every and all courses of action of treatment?
Some other experts in the industry, as we've talked about, Dr. Strange and Dr. Titchener, who also act in treating COVID-19, suggest that supportive care is not the standard of care, that it's merely, a piece of tape on a leaky faucet, I believe Dr. Strange referred to it as. For a patient whose condition is worsening, ivermectin and Math Plus are relatively non-invasive compared to sedation, intubation, and ventilation, and putting someone in an induced coma. It is definitely worth giving thought to, and at least reviewing the literature to a meta-analysis that shows some positive effects of COVID-19 and pursuing that due to his interest to act in her best interest. Does that?
Thank you. I just have one follow-up question with respect to the transfer of Ms. Stark. Why did those that were caring for the plaintiff not seek transfer of Ms. Stark earlier? And second question, when Ms. Stark was transferred to the care of Dr. Strange, did Dr. Strange initiate the Math Plus treatment? I was looking for that in the facts, and I couldn't see the answer to that.
So I'll answer your last question, and I'll move backwards. Unfortunately, due to the delay Dr. Lutzier imposed with his failure to agree to transfer Ms. Stark, there was 6 days between the time that he decided he had exhausted all possible treatment opportunities and 6 days between then in which he agreed to transfer her, despite Dr. Strange's pleas. That during that time, by the time she arrived at Fallsview Health, she died within an hour of her arrival. So there was no opportunity to engage in any kind of alternative treatment. So that was due to that unacceptable delay. Ms. Stark's family and Dr. Strange actively made efforts to speak with the physicians and to have some type of agency in Ms. Stark's care. The unfortunate reality is they were denied time and time again to exert any kind of agency in her care. Nurse Patel was chastised for speaking with the family and for then taking the opportunity to use the Math Plus protocol. She was told not to speak with the family, and so they were punished for their input in Ms. Stark's care. Math Plus and ivermectin were administered both times once on the deceased. The first time it was ivermectin, and there was considerable improvement, and that was under the leadership of Dr. Papadopoulos. And then the second time it was under Nurse Patel under supervising physician Andy Park. So there was some, when Dr. Lutsier was not consistently withdrawing the care, there was belief by other physicians on the floor that Ms. Stark would benefit from this and that she was not responding to supportive care and that additional measures were needed to be taken. Unfortunately, both times she improved following the use of those drugs, and both times Dr. Lutsier intervened, removed it, and she proceeded to deteriorate further.
Sorry, Ms. Hunter, can I ask one further question? The second breach that you point to, the failure to read the literature that was submitted by Dr. Strange, do we need to have evidence as to what Dr. Lutsier would have done had he reviewed that literature in order to make a finding on that breach? Or is it sufficient in your submission that it be proven that he did not review the literature?
Justice, we submit that it is sufficient that he did not review the literature. He had a due diligence to act in Ms. Stark's best interest, and that would have included reviewing literature that another critical care specialist was claiming to be in her best interest and claiming to be an alternative method of treatment. The alternative here was between reviewing the literature, was watching Ms. Stark die. He had exhausted all treatment methods. It could not have been more convenient for him to review it.
Ms. Hunter, just in follow-up with that, you submitted that he didn't review the literature, but you also submitted that he was part of the policy-making committee of the hospital. So you're saying that he made policy in the hospital without reviewing literature and that he did this on his own? Or are you aware of the committee that was struck at West Valley to come up with the policy for treating COVID-19 patients, and therefore a review of the literature done by others in addition to Dr. Lutsier?
The committee did review different research on ivermectin, remdesivir, dexamethasone throughout their construction of the hospital's COVID-19 protocol. We do concede that literature has been at one point reviewed. The thing is when the hospital guidelines are being updated so frequently and literature is changing in regards to—
So you can see that Dr. Lutsier did read the literature then while forming policy for the hospital?
At one point, yes, he did.
So he would be justified in not reviewing the additional literature supplied to him by Dr. Strange, feeling confident that he had an adequate understanding of the literature prior to that.
He must have been confident that he had an adequate understanding. However, unfortunately, that's not sufficient when we have something like COVID-19, where the literature is so quickly evolving and the stances on particular drugs are changing. The World Health Organization just removed their support of remdesivir. As such, we just use this to support the claim that information is changing and doctors have a duty to maintain and be up to date with evolving literature.
That's an excellent point, Ms. Hunter. Can you provide any evidence from societies, critical care society, or consensus conferences that support the use of ivermectin as opposed to single doctor recommendations that you submitted?
The FLCAA support the use of Math Plus, and that is a board of certified physicians who advocate for the use of Math Plus. Ivermectin as well is currently undergoing trials actually in conjunction with remdesivir. So there is literature out there. The meta-analysis that Dr. Strange submitted had 58 ivermectin peer-reviewed studies, including statistical methodology, control of variables, an understanding of safety and adverse reactions, as well as some randomized controlled trials in regards to mortality and vital clearance results. So there was valid and reviewed information within the meta-analysis that she submitted to him, and there is that information out there that is supported by other physicians.
Thank you. I think your time is up. Thank you, though. And then I invite your co-counsel, Ms. Sager, to have her 15 minutes.
Hello, Justices. My name is Kayla Sager, and I will be presenting 3 submissions to this honorable court on behalf of the plaintiff. I will begin by arguing that the damages sustained by Ms. Stark were caused by Dr. Lutsier's breach of the standard of care. Next, I will argue that the damages sustained by Ms. Stark should amount to a total of $12 million. Lastly, I will argue that West Valley Memorial Hospital is vicariously liable for the damages sustained by Ms. Stark. On the first submission, the plaintiff argues that although the but-for test is typically used to determine causation, the appropriate test for the case at hand is the material contribution test set out in Forsberg and NATO. The material contribution test is applicable to the case in front of this court due to the novel and consistently changing information and scientific knowledge surrounding COVID-19. In Hank and Resurface Corporation, the Supreme Court of Canada set out a two-pronged test for the application of the material contribution test in determining causation. The Supreme Court of Canada set out two prongs, which consisted of the first being that it is impossible for the plaintiff to prove that the defendant's negligence caused the injury using the but-for test, and the second prong, that it is clear that the defendant's breach of the duty of care owed to the plaintiff exposed the plaintiff to unreasonable risk of injury. The lack of consistency in the administration of ivermectin to Ms. Stark between the time of her initial deterioration and her COVID positive test on October 1st to the point of her death on October 19th makes proving the but-for test impossible. Ms. Stark was administered ivermectin on October 7th, but was immediately withdrawn from its use. Ms. Stark was again administered ivermectin on October 10th. However, Dr. Lutzier again rescinded its administration and further denied Ms. Stark Math Plus protocol. It is unclear whether this isolated, inconsistent, and unregulated administration of ivermectin would have had a positive impact or not on the preservation of Ms. Stark's life. Thus, the but-for test cannot be applied. Nonetheless, Dr. Lutzier's conscious decisions to continue administering supportive care, which displayed no clear evidence of effectiveness, as well as the inconsistent administration of ivermectin or Math Plus, a possibly effective and life-saving treatment, increased Ms. Stark's possibility of damage and ultimately death caused by COVID-19. Dr. Lutzier's actions were more than laziness or simple misjudgments. Dr. Lutzier's actions led Ms. Stark to suffer undue harm that she, a healthy 28-year-old, may not have otherwise suffered. Next, I will move on to the second prong of the material contribution test.
Ms. Sager, before you do that, just following up on a question that Justice Embry had for your friend, whether we're talking about the but-for test or the material contribution test, how do we get there if we don't know what? So speaking specifically about the breach that you allege was a failure to consult the literature or review the literature, how do we find causation under either but-for or material contribution if we don't know what Dr. Lutzier would have done had he reviewed the literature, how that would have changed things?
Right. Pursuant to the material contribution test, its application is contingent on the fact that but-for cannot be applied due to a lack of hard scientific information. The nature of COVID-19 instills that no one truly knows which treatment will be beneficial for each patient. Still to this day, despite the fact that we've been in the pandemic for quite some time, there still exists inconsistencies in the use and treatment courses for COVID-19. Thus, it follows that Dr. Lutzier had an obligation to at least seek out alternative treatment plans when he was presented with Ms. Stark's case in the ICU. And he failed to do that, thus increasing the harm that she would have otherwise not been susceptible to. Ms. Stark was young. Dr. Strange in her in the moot problem states that Ms. Stark had a likelihood of survival of 90 to 98% relative to the other cases she had seen. Thus, Dr. Lutzier should not have
Yeah, I understand the argument with respect to the treatment. I'm speaking specifically though about the breach, a failure to look at the literature, because if he says I would have looked at the literature and I still wouldn't have administered the treatment or ordered the treatment, isn't that a problem for you in proving causation?
Right. The argument of the plaintiff rests on his bias relative to him not even reading the literature. If he had read the literature, maybe he would have changed his perception. Rather, he went in with a bias that such treatment courses were a result of propaganda, and that clouded his judgment and forced him to not even consider administrating. If he had opened up those studies, his decision may have been different, and Ms. Stark may be with us today.
Ms. Sager, part of your submission has to be the incremental benefit of ivermectin. So are you aware that even if Dr. Lucier had treated the plaintiff with ivermectin, what would be the differential survival as it leads to causation in this case?
Right. Thank you for your question. The plaintiff admits that Ms. Stark was not given ivermectin for a long enough period. Ivermectin during one simple dose would not have been adequate to see positive impacts on her care. Thus, it was of the duty of Dr. Lucier to consider administering ivermectin for a longer duration than simply those that were given by other physicians.
But even if she had the full recommended dose of ivermectin, what was her survival relative to compassionate care?
Right, that is still unclear due to the changing information with COVID-19 and the novelty of ivermectin.
Isn't that a problem for you to prove causality then, if it's unclear what the effect of ivermectin is?
It's unclear, it's difficult for the plaintiff to prove direct causation. However, that is why we rely on the material contribution test to determine that Dr. Lucier's actions led to an increased level of harm to Ms. Stark that she would have not suffered if she had been given the opportunity to be considered for other treatment plans. If that is all the questions from the bench, I will continue on with my submissions.
Sorry, I just have one further one. I do apologize, Ms. Sager, but you mentioned Dr. Strange's evidence that the survival rate for someone such as Ms. Stark would have been in the 90 to 98% range. That's not specific to the use or non-use of ivermectin or MAF plus, is it? That's a overall survivability rate for that patient population when faced with COVID, regardless of the treatment, or do I have that wrong?
Right, so Ms. Stark is a proponent for MAF plus and ivermectin administration. What it is known to this court is that Dr. Strange did not rely on supportive care, and thus those survival rates are not with respect to supportive care, but rather other courses of treatment, such as those that are in front of the court today. I will next discuss the second prong of the material contribution test, simply briefly as my co-counsel, Ms. Hunter, has already alluded to it. Dr. Lucier breached the standard of care when he failed to examine the literature and failed to consider administration of ivermectin or MAF plus. Furthermore, ivermectin alone or MAF plus does not interfere with supportive care, the care that Ms. Stark was receiving under Dr. Lucier's attention. Thus, Dr. Lucier could have considered administering those treatments and could have safely provided them to Ms. Stark, ultimately leading to a decrease in harm that she would suffer from COVID-19. I will next discuss my second submission, that the plaintiff admits that the damages sustained by Ms. Stark should total an amount of $12 million. I would like to amend the total within our factum, which sets out a claim for the damages of a total of $21 million. I will proceed with my submissions on the grounds that the plaintiff is seeking damages for the value of $12 million, if that satisfies the court. Ms. Stark was impressive. Ms. Stark was the general manager of the Toronto Raptors Basketball Club, held an MBA and a JD. She was ambitious. She would work likely for a long period of her life between finishing her career with the Toronto Raptors and working in the legal or business sectors, earning an average income for the Toronto Raptors of $15 million for the extent of 5.5 years, and earning an average of $100,000 per year within the legal and business sectors. It follows that under the sole modified dependency approach, as set out by Nielsen, al. and Kaufman, Mr. Stark should be allotted a 60% dependency rate and Peter Stark a 4% dependency rate, leading to a total of just shy $12 million. With respect to non-pecuniary damages pursuant to Section 61(2)(e) of the Family Law Act,
Thank you,
Mr.
Ms.
Stark,
Sager. I have a quick question before we move on to non-pecuniaries. I just have a quick question about the loss of income. Do you have any data on what female general managers in the NBA were compensated? I understand you are basing your numbers on Usai Majeri, but want to know if there's any data on what female general managers in the NBA were being compensated for.
Right. Unfortunately, females within those high-level positions are few and far between. We do not see females holding high positions in sports or even general positions within the business and legal professions. Although that is changing, there is no indicative evidence that of the average between other female general managers and Ms. Stark. Thus, we had to rely on the closest thing available to our argument, and that being the previous general managers of the team that she currently is residing with.
A follow-up question then. Thank you for that. In your view, should there be any difference in what the court can expect as a reasonable compensation for an NBA general manager, regardless of gender?
I think that I believe that the number we have provided, the 15 million for the 5.5 years, takes into consideration maybe the lower income that a female would have provided, but guarantees that balance on the basis that Ms. Stark is highly qualified. She has a JD as well as an MBA, and thus that balances out the loss that could potentially be associated with her gender.
Sorry, one more question on that. Do we know what she was actually making under her contract? Because I see the contract terms for the former GM, but I don't see in your factum her contract terms.
Unfortunately, the plaintiff does not have access to Ms. Stark's employment contract under the Toronto Raptors. This information was not provided to us, and thus we had to rely on external evidence as to support this submission.
So then one follow-up question, do we know what the background was of the former general manager? Did he have more experience, for example, than she did when he obtained his 5-year, $15 million deal?
Right. It follows that the former general manager was older than Ms. Stark when he entered the Toronto Raptors team. However, that does not preclude the fact that Ms. Stark was highly educated, something that the former general manager was not.
And do we know that the NBA would have compensated her for that education as opposed to the experience that the former general manager, Masai, had?
That is unclear to the plaintiff and the court at hand today. However, it must be noted that general managers are not often educated. That is something that is a commodity, especially due to the fact that being a general manager is highly intertwined in the business and international business realm. Thus, it follows that the NBA would have qualified Ms. Stark's education as important.
And with respect to the income loss forecast, meaning your projection of what Ms. Stark would have earned into the future, does that take into account any negative contingencies, or in other words, any bad things that would have happened to Ms. Stark that would negatively impact her ability to stay employed as a lawyer until age 65?
Absolutely. The $100,000 per year that the plaintiff submits for the loss of income within the legal or business sectors up until the age of 65 is a stagnant figure for that entire period of time. It does not consider the fact that Ms. Stark or any individual, as they increase in seniority in a role, would be accompanied with raises or bonuses. Rather, this stagnant rate takes into consideration that Ms. Stark may be off for periods of time due to illness or taking care of her son.
Thank you so much.
I will now, sorry.
Oh, I'm sorry, your time is up. That's okay. Thank you, though. So the court now invites counsel for the defendant to begin.
Good afternoon, Justices. My name is Monique Kahlon, and I'm here today with my co-counsel, Nicole Davidson. We are counsel for the defendants in this matter, Dr. Justin Lenczner and West Valley Memorial Hospital. I will be dealing with standard of care. My co-counsel will then make submissions on causation and vicarious liability. Altogether, our submissions will demonstrate that while this was a very tragic outcome for Kyla Stark, the court should find that there is no liability for negligence in this case. Especially during a global pandemic, we submit the court should not set a precedent where healthcare heroes fear being accused of negligence for following the accepted standard of care. My submissions have three main points. One, the requisite standard of care for medical negligence in Canada is the standard of the reasonably prudent doctor. Two, Dr. Lenczner did not reach the standard by choosing not to review the literature provided by Dr. Sophia Strange. And three, Dr. Lenczner did not reach the standard by declining to treat Ms. Stark with Math Plus or ivermectin alone. My first point sets out the requisite standard of care as it applies in this case. It is established that the standard of care for doctors is to conduct their practice in accordance with the conduct of a reasonable, prudent, and diligent doctor of the same experience and standing. When a doctor presents themselves as a specialist, they are held to a higher standard than a general practitioner. In this case, the degree of care, skill, and knowledge required of Dr. Lenczner was that of a similarly situated and experienced pulmonary and critical care specialist. It is crucial to remember that the standard of care does not expect perfection from our doctors. Rather, the standard is one of reasonable care. We submit that the counsel for the plaintiff have not met their burden to prove that there was a breach of the reasonable standard of care. Dr. Lenczner exercised reasonable care in his treatment of Ms. Stark, as expected of a reasonably prudent pulmonary and critical care specialist. Moving to my second point, Dr. Lenczner did not breach the standard of care by choosing not to review the provided literature, as he had a good reason to not examine the data, which is the standard of a reasonably prudent and diligent doctor. In fact, Dr. Kahlon Moriarty, who has significant experience working in the ICU during the COVID-19 pandemic, stated it would be strange for a doctor to not investigate the provided literature unless the doctor had solid evidence to refute the studies or another good reason to not examine the data. Dr. Lenczner was aware that the evidence in support of ivermectin is lacking and that many leading medical societies, such as the National Institutes of Health, have determined that the studies on ivermectin are insufficient. The main concern is that most of the studies in support of ivermectin are flawed due to significant limitations. Dr. Lenczner was aware of these limitations. Furthermore, Dr. Lenczner has monthly meetings with a team of experts and specialists to review the literature. The very goal of these meetings is to keep their knowledge current by reviewing the latest literature. This literature is reviewed as it is published, so the team has the most up-to-date medical knowledge. Based on these facts, it can be concluded that if there was high or even medium quality evidence for ivermectin or Math Plus, Dr. Lenczner would have been aware. In the plaintiff's factum, my friends state that a prudent and diligent physician must continue to maintain his or her medical knowledge and keep up with scientific developments. We agree and further submit that the actions of Dr. Lenczner show his desire to ensure he was up to date on the latest literature, like any reasonably prudent and diligent physician. Thus, we submit that Dr. Lenczner did not breach the standard of care by choosing not to review the provided literature because he was relying on more significant medical knowledge. During his care of Ms. Stark, Dr. Letzier followed the hospital's COVID-19 treatment guidelines, which did not include either Math Plus or ivermectin. I would like to clarify, as my friends admit, that the hospital treatment guidelines were created by Dr. Letzier. However, it was created by a team of experts and specialists, including Dr. Letzier. As such, Dr. Letzier chose to rely on the extensive knowledge that he obtained with an interdisciplinary team, rather than the information provided by one doctor that he reasonably felt was unreliable. As I stated earlier, the standard of care is not a standard of perfection. We submit that Dr. Letzier cannot be held to a standard of perfection where he must read every study every time it is sent to him. This is simply not possible, especially during busy times such as the COVID-19 pandemic. In Lapointe and Hôpital Le Gardeau, the Supreme Court held that doctors should not be held liable for mere errors of judgment, which are distinguishable from professional fault. Specifically, errors of judgment are distinguished from acts of carelessness, unskillfulness, or lack of knowledge. At worst, Dr. Letzier's choice to not review the provided literature can be classified as an error of judgment, and that is not sufficient to establish a breach of the standard of care. He made a reasonable and intelligent decision to prioritize the care of his patients using the hospital's COVID-19 treatment guidelines, which was established by a team of experts and reviewed monthly. It cannot be said this decision was an act of carelessness or unskillfulness. To conclude my first point, Dr. Letzier's choice to not review the literature provided by Dr. Strange cannot be considered a breach of the standard of care. Moving to my last point, it is generally accepted that doctors will not be found liable for negligence when their actions conform with the respectable and recognized practice of the profession. The only exception to this is when it can be established that the common practice itself is negligent. However, this requires obvious risks or dangers associated with the common practice that can be understood by the ordinary person. Dr. Letzier followed a course of treatment known as supportive care when treating Ms. Stark. At the time and to this day, supportive care is recognized by medical science as being the most appropriate treatment for COVID-19. The CDC has stated that the clinical management of COVID-19 includes supportive care, even for patients with severe disease such as Ms. Stark. Supportive care is a part of the hospital's COVID-19 treatment guidelines, which were developed by a team of experts, as I've said. Supportive care also includes drugs such as remdesivir, which is the only drug approved by the FDA to treat COVID-19 in hospitalized adults. Health Canada has also authorized the use of remdesivir as a treatment for COVID-19, and Health Canada only authorizes treatments after a thorough scientific review. Leading societies in medicine and federal health agencies recognize supportive care as the standard of care. This is strong evidence that Dr. Letzier adhered to the reasonably prudent standard instead of trying experimental therapies. Moreover, there are no obvious risks or dangers associated with supportive care to show that the standard itself is negligent. Further, doctors—
Sorry to interrupt. What do you say to the fact that the patient appeared to improve when these treatments were administered and deteriorate when they were withdrawn?
Thank you, Justice. So we submit that although there were two instances where Ms. Strange did improve after receiving Math Plus, ultimately correlation does not equal causation. And we also submit that there can be instances where, although she initially improved, that ultimately she did deteriorate because of being provided Math Plus and ivermectin. My co-counsel will be addressing that in detail in her submissions.
I have a question about your reference to Dr. Moriarty, your expert evidence. As I understood what you said, it was that Dr. Moriarty, I think, said you should look at the literature unless you have a good reason not to review it or something like that. Was that what you said his evidence was, or her evidence was?
Yes, correct.
So your friends say in their factum that he conceded it would be a breach of standard if he brushed off the research as propaganda. And I've also heard evidence from them, reading from the record, that there were comments from the defendant, Dr. Letzier, to that extent. So what do you have to say about that in terms of the expert that you're relying on, the expert evidence that you're relying on?
Thank you, Justice. Although Dr. Letzier may have made some comments, ultimately the point we are making is that His reasoning for that, for not relying on that data, is because he had more significant knowledge, which is the other knowledge that he reviewed with his team of experts and specialists. And Dr. Moriarty did say that, well, yes, I would review that literature, like it is a standard, unless he did reiterate that there is another reason that the doctor can point to. And in this case, we are saying Dr. Lenczner did have that other reason. Does that answer your question?
If I can ask you a question, Ms. Kahlon, you've cited, national societies and their recommendations and their acceptance of supportive care as a treatment for COVID. However, there's always regional differences in care, especially access to care. Do you have any supporting physicians or care providers at West Valley to say that if Ms. Stark came in under anyone else other than the defendant, that she would have had a different course of action?
Thank you, Justice. Unfortunately, we do not have that information. However, the hospital's policy, which all physicians should be following in that hospital, is supportive care. So although we cannot make inferences on what other doctors will do in the moment, that is what they should be following. That is the standard of care. Thank you. So further, Dr. Strange and Dr. E.B. Titchener may argue that the standard of care in this case was the administration of ivermectin and the other components of MAP+, rather than supportive care, but it is still important to consider the scientific evidence. The FDA may authorize unapproved drugs or unapproved uses of approved drugs under certain conditions due to the emergency use authorization. Currently, 14 COVID-19 treatments are authorized for emergency use, but ivermectin is not one of them. Both the FDA and Health Canada had not authorized or approved the use of ivermectin for treating COVID-19 because the current evidence does not show that it is safe or effective. As such, regardless of any data that Dr. Strange may have presented, Dr. Lenczner had every reason to believe that ivermectin could cause more harm than potential benefit when treating Ms. Stark. Often in medicine, there are multiple treatment options available, even when we are not dealing with a situation as novel as COVID-19. However, the Supreme Court has held that a doctor will not be found liable for negligence if the treatment provided to a patient corresponds to what is recognized by medical science at the time, even in the face of competing theories. Essentially, courts should not become involved in controversial questions regarding the treatment of preference, and we submit that is the case in this situation. In light of competing theories regarding the treatment of COVID-19, Dr. Lenczner chose supportive care, which cannot be considered a breach of the standard of care. In fact, with insufficient evidence supporting either ivermectin or MAP+, it would have been negligent for Dr. Lenczner to abandon a treatment plan supported by multiple health organizations. We cannot deny that the death of Ms. Stark was a terrible tragedy, but Dr. Lenczner had every reason to believe he was making the right choice in treating her. He chose to follow the science like any reasonably prudent and diligent doctor. To conclude my submissions, we respectfully submit that Dr. Lenczner did not breach the standard of care by choosing not to review the literature provided by Dr. Strange. Dr. Lenczner had significant knowledge of the high and medium quality literature for the treatment of COVID-19 to provide Ms. Stark with the appropriate evidence-based care. Further, we respectfully submit that Dr. Lenczner is not liable for medical negligence, as he chose to follow the hospital's COVID-19 treatment guidelines and use supportive care instead of potentially harmful treatment. Subject to any further questions, that concludes my submissions. My co-counsel will now address the remaining two issues.
Good afternoon, Justices. My name is Nicole Davidson, and I will be dealing with the final two issues on causation and vicarious liability. I have 2 points on my submission. First, Dr. Lenczner did not cause or contribute to Ms. Stark's tragic passing. And second, the hospital cannot be found vicariously liable because Dr. Lenczner met the standard of care. My first point sets out the applicable test for finding causation. I will also consider the facts of this case and the relevant medical literature to demonstrate why causation has not been proven on a balance of probabilities. Even if this court determines that Dr. Lenczner breached the standard of care, we submit that he is shielded from liability because the plaintiffs have failed to meet their burden of establishing a factual causation between Dr. Lutzier's actions and Ms. Stark's death. Factual causation is established by applying the but-for test. The plaintiff must prove that the harm would not have occurred but for the negligence of the defendant. The plaintiff carries the burden of showing that it was more likely than not that adequate treatment would have prevented the outcome. It is not enough to show that adequate treatment would have afforded a chance of avoiding the outcome, unless that chance passes the threshold of more likely than not. This court bears the responsibility of determining whether the plaintiff has met his burden of proving causation on a balance of probabilities. Now, we'd like to point out that our friends erred in applying the material contribution test to determine causation. Their attempt to rely on material contribution fails at stage 1 of the test, where they claim that lack of scientific knowledge regarding COVID-19 treatments renders it impossible to prove Dr. Lutzier's negligence using the but-for test. Respectfully, in Clements and Clements in 2012, the Supreme Court clarified that scientific precision is not required to prove causation. In addition, the impossibility the material contribution test seeks to rectify is a situation where there are multiple negligent defendants, but it is impossible to prove which one caused the harm to the plaintiff. To date, this test has not been applied in a case with just one alleged wrongdoer. The goal of the material contribution test is to prevent cases involving multiple defendants from pointing the finger at each other, where it is impossible based on the facts to prove who caused harm to the plaintiff. The material contribution test is also not applied in cases where there is a chance that the plaintiff's injury is due to factors unconnected to the defendant. The plaintiffs erred in relying on the material contribution test in this case because there is only one alleged wrongdoer, and there is a chance that Ms. Stark's death occurred due to factors outside of Dr. Lutzier's control. Therefore, in relying on this test, our friends have not met their burden of establishing that but for Dr. Lutzier's actions, Ms. Stark's death would not have occurred. Even if our friends applied the but-for test, they are unable to prove on a balance of probabilities that but for Dr. Lutzier withholding Math Plus or ivermectin, Ms. Stark would have survived. Even if Dr. Lutzier had read the studies provided by Dr. Strange, it is unlikely it would have changed his course of treatment. When Ms. Stark was admitted to the hospital, she was experiencing what are classified as moderate to severe COVID-19 symptoms, with severe shortness of breath and mild hypoxia. The studies provided by Dr. Strange are inconclusive regarding ivermectin's efficacy in treating moderate to severe COVID-19 symptoms. The National Institute of Health has looked at these randomized controlled trials on ivermectin and has identified key limitations for each. These studies are simply insufficient and do not speak to the efficacy of treating severe COVID-19 symptoms with ivermectin. Furthermore, the National Institute of Health confirms that using remdesivir in conjunction with dexamethasone is the appropriate treatment for moderate to severe COVID-19. Health Canada also backs this treatment. We also submit that the correlation between Ms. Stark's condition improving and treatment with ivermectin and Math Plus is not enough to establish causation. Twice in the course of her stay at the hospital, physicians stopped the standard treatment plan and provided either ivermectin or Math Plus protocol to treat Ms. Stark. Our friends draw a correlation between Ms. Stark's condition improving and these treatments. However, as the facts show, ivermectin was administered to Ms. Stark on day 6 after onset of illness. Her symptoms did temporarily improve, but the next day she was placed on a mechanical ventilator for the first time since being admitted to hospital. Her condition improved again after Math Plus protocol was administered around days 9 to 10. But then she deteriorated around day 12 and again was placed on mechanical ventilation. Now, the Math Plus literature provided by Dr. Strange states that delayed treatment can result in complications, such as the need for mechanical ventilation. The FLCCC Math Plus protocol states that it should be administered soon after the patient requires oxygen supplementation, and that would be within the first hours of arriving at hospital. In Ms. Stark's case, Math Plus was administered days after she required oxygen supplementation. So while it is merely possible that Math Plus and ivermectin improved Ms. Stark's condition, it is also possible that deviating from the standard treatment plan and delayed treatment with Math Plus resulted in further complications. As of October 19th, 2021, Health Canada warns health professionals against using ivermectin to treat COVID-19, explaining that Health Canada has not received an application for clinical trials for the use of ivermectin for treating COVID. Additionally, in Dr. Strange's deposition, she concedes that the College of Physicians and Surgeons issued a warning to her to stop administering ivermectin to treat COVID. The facts before you are clear. The regulatory body for physicians and federal health agencies do not recommend treating COVID with ivermectin due to the lack of evidence and the inherent risks.
Thank you very much, Ms. Davidson. I appreciate your submissions. What do you say about the troublesome or challenging fact that you have, which is the case that the hospital did in fact use ivermectin to treat this patient, not on one but two occasions?
Thank you for your question. You do raise a very good point that it was in fact administered against the recommendations of health agencies and against what the CPSO would advise. Now, I would just like to mention that that is not a concern before us, because the concern ultimately is what with Dr. Lutzier withdrawing ivermectin or Math Plus, and that is what the plaintiffs have brought before you today. If they do have concerns with deviation from the standard, then that would have to be an issue in a separate matter before the court. Does that answer your question?
Yes, it does. Thank you.
Thank you. I would also like to point out that it is possible that Ms. Stark's deterioration was due to the virus alone. The CDC warns that some COVID-19 patients will rapidly deteriorate about a week after onset of illness. Furthermore, other sources indicate that while patients may start to feel better around days 7 to 8, the symptoms can worsen after that. This lines up with Ms. Stark's condition. She was moved to the ICU on day 5 after onset, and on day 7, she worsened and was intubated and placed on a ventilator. The plaintiffs have presented theories about the efficacy of Math Plus and ivermectin that are not backed by government health agencies such as the FDA, CDC, and Health Canada, who all recommend treating COVID with remdesivir and recommend against the use of ivermectin. Both sides accept without a doubt that complications resulting from COVID-19 caused Ms. Stark's death. Unfortunately, Ms. Stark entered the pulmonary phase of COVID-19 during her stay at the hospital and developed advanced lung disease as a result, which is the leading cause of death in COVID-19 patients. The question is whether by withholding ivermectin or Math Plus, Dr. Lutzier contributed to her death. This court bears the task of weighing the evidence before it and determining whether it is more likely than not that Dr. Lutzier's actions caused Ms. Stark's death. However, the evidence and studies before us simply do not point concretely to this conclusion. Nothing in the evidence before us indicates that it is more likely than not that ivermectin and Math Plus are effective against severe COVID-19, which Ms. Stark was battling. Furthermore, COVID is a novel virus, and we are still learning so much about it. What we have learned about COVID is that it does not discriminate when it comes to who gets sick and how sick they get. For these reasons, the plaintiffs cannot say with probability that Dr. Lutzier withholding Math Plus caused or contributed to Ms. Stark's death. To conclude my first point, the plaintiff has failed to meet the burden of proving causation, and therefore Dr. Lutzier cannot be found liable in medical negligence. Moving to my final point, West Valley Memorial Hospital is not liable for Dr. Lutzier's actions because Dr. Lutzier met the standard of care and did not cause or contribute to Ms. Stark's harm, and thus is not liable in negligence. The hospital may only be found vicariously liable if a salaried physician is negligent in their care of the hospital's patient. There is no liability without negligence. In order to establish vicarious liability, 3 requirements must be met. First, the plaintiff must establish that the employee is liable in negligence. Second, there is an employer-employee relationship between Dr. Litzier and the hospital. And third, that the tort was committed in the course and scope of employment. We do concede that Dr. Litzier is a salaried employee of the hospital, so naturally, an employer-employee relationship exists. However, as myself and my co-counsel have explained, Dr. Litzier is not liable in negligence because he followed the standard of care and because the plaintiffs have failed to meet their burden to establish causation on a balance of probabilities. Since we submit Dr. Litzier is not liable in negligence, it follows that the hospital cannot be held vicariously liable. To conclude my submissions.
Sorry, can I
Ms.
just
Davidson, to interrupt you, but
go ahead,
there was
Dr.
one
Ross.
point in the plaintiff's factum where the treatment of ivermectin was administered to the plaintiff. However, the hospital nurse claimed that the hospital had run out of supplies and was unable to continue the therapy. How was the hospital not responsible for maintaining supplies of treatment?
Absolutely. Well, in this case, the liability that we're looking at is whether the hospital is vicariously liable solely for Dr. Litzier's actions. So the fact that the ivermectin was replaced is not an issue that's before the court. What we're looking at here is whether, due to Dr. Litzier breaching the standard of care, is the hospital responsible as a result.
So I just have a clarification question. Then. So you concede that if we were to find Dr. Litzier negligent, you concede that the hospital then is vicariously liable for that?
If you do find him negligent, that he breached the standard of care, then we would concede that the hospital as a result would be vicariously liable. To conclude my submissions.
Quick question on that one point, Ms. Davidson, thank you so much. If the hospital expects its medical staff to stay informed and educated on modern treatment, would you say that by failing to read and consider Dr. Strange's literature, Dr. Litzier was acting outside of his course of duties?
Thank you for your question. I do not believe in this case that he was acting outside of his duties. And as my co-counsel submitted, and as we maintain, even if the court finds the studies, we look at this as an error of judgment, and we can't judge Dr. Litzier too harshly in hindsight. Now, we have to remember that this is a busy ICU during a global pandemic when the hospitals have been overrun for over a year. Not reading the studies in one instance does not make out negligence. And in that case, I think it would only add up to an error in judgment in this case.
Thank you.
Thank you. Now, being mindful of my time, I do have about a minute left, so I will conclude my submissions. We respectfully ask that this court not find against Dr. Litzier for negligence. In times of a global pandemic, the court should not set a precedent that encourages doctors to deviate from the standard of care set out by federal health agencies and instead deploy experimental treatments that the vocal minority is pushing for. This would put patients at greater risk, and the public would lose confidence in the healthcare system. Doctors should not fear liability and negligence for following the accepted standard of care. As a result, this court should not find Dr. Litzier nor the hospital liable for damages owed to the plaintiff, and we seek the award of costs as a result and such further and other relief as this honorable court deems just. Subject to any further questions, that concludes my submissions.
Thank you.
I do have one question about damages from the defendants. We heard from your friends as to what they were seeking in terms of damages, and they've increased their prayer for relief at this hearing. Is there any submissions you want to make on damages, or should the court accept the damages that your friends are putting forward?
Thank you for your question. Respectfully, the issues before the court that we were submitting on were standard of care, causation, and vicarious liability, and we would simply maintain that damages not be awarded because the standard of care has not been breached. However, if you would like a more fulsome submission on damages, we would request to submit it in writing after the fact.
Thank you very much, Ms. Davidson.
Thank you.
Thank you. The court now invites counsel for the plaintiff to begin their optional 3-minute rebuttal if they wish to have it.
Sorry, I forgot to unmute myself. Apologies. Thank you, justices, for your time today. Once again, the plaintiff would like to submit that it isn't uncommon for physicians to engage in experimental treatment. Dr. Lenczner testified that if he felt a patient would benefit from an off-label drug, then he would prescribe it, and that he had done so in the past. Yet when the options were watching Ms. Stark deteriorate or review the literature demonstrating the benefits of MAF Plus or ivermectin, Dr. Lenczner refused to review the literature. Ivermectin has been subjected to 126 studies. 82 of those have been peer-reviewed, including a statistical methodology, control of variables, an understanding of safety and adverse reactions, and 64 with results comparing to the treatment and control groups. Over 20 countries have adopted ivermectin in treating COVID-19. How can Dr. Lenczner in good conscience say that ivermectin is dangerous or refuse to even review the literature when he hasn't reviewed the literature? The trials he looked at when, the research he looked at when developing the protocols are now out of date. Medicine and our technological developments in regards to COVID are so quickly evolving that he needed to maintain and be diligent in keeping up to date with COVID-19 developments. He frequently references the National Institute of Health and its negative opinion of ivermectin. However, this has since changed. In January 2021, they reversed their stance to a neutral stance. Ivermectin has been around for decades, 34 years, 3.7 billion doses worldwide, and less than 100 deaths in over 35 years. He relied on the FDA for the green light in regards to remdesivir, but was unfamiliar with summary reports of Health Canada issued, which acknowledged a link between the use of remdesivir and the risk of sinus bradycardia. We say this simply to assert that it is a physician's duty and it is within the standard of care, especially in the context of treating COVID-19, to be up to date with developments within the field. He must be held accountable to this breach. Furthermore, if we apply the but-for test for causation, the plaintiff submits that but for his inaction to pursue other treatment avenues, Ms. Stark would not have met her end as she did. We submit that the defendant breached the standard of care by not reviewing the literature and by his failure to initiate the MAF Plus or ivermectin alone as a treatment protocol, and that he should be held liable for his negligence, and that the hospital should be held vicariously liable as such. Thank you so much.
Thank you. So this concludes the matter of Stark v. Lenczner.